I call the Board of Adjustments and Appeals meeting to order. Ms. Work, please take the roll.
Mr. Cole,
Here.
Ms. Ozzles,
Here.
Mr. Friesen,
Present.
Mr. Koenig,
Here.
Mr. Collins, Ms. Dickerson,
Here.
Chair Taylor.
Present. All right, first up on the agenda, we've got approval of the minute. Can I please get a motion and a second?
I so move.
Second.
Was there anyone not here that needs to abstain before we take the vote? All right, everyone here. All right, so we could do a voice vote. All in favor, please say aye.
Aye.
Any opposed? All right. We do not have an approval of findings of facts. So next up is the public forum. This is an opportunity for the public to address the board regarding items not on the agenda. So if you're here to speak on the case for 3336 South Marion Street, that will be in a moment coming up on the agenda. But this public forum is a chance, board members and staff will not engage with the dialogue or answer questions at this time. Speakers who wish to speak on a topic not on tonight's agenda may be directed to staff or other sources for responses at a later date to questions raised during this public forum. Presentations are limited to 3 minutes. Questions and comments may be also emailed to comdev@inglewoodco.gov. Is there anyone here tonight that will wish to speak on a topic that is not on the agenda tonight? Is there anyone online? Okay. So we can move on to the public hearing for case VAR 2025-006. Yes, there are 6 members present tonight, therefore 5 votes will be required to approve variance. The board is authorized to grant or deny a variance by Part 3, Section 60 of Inglewood City Charter. Anyone aggrieved by a decision rendered by this board may appeal that decision to a court of record. However, such an appeal must be made within 30 days of the board's decision. Any approved variance is effective at the end of the appeal period. Building permits for construction associated with an approved variance will not be issued until the appeal period is ended. Building permits must be obtained and construction begun within 180 days of the variance's effective date. Procedure for the meeting is that the case will be introduced and an overview will be given by staff. The applicant will present their request and the reasons that our approval should be granted. Proponents will be given a opportunity to speak. Opponents will be given an opportunity to address the board. And then, if needed, staff can address the board again. The public hearing for case VAR-006 for Trevor and Kristen Pyle at property at 3336 South Marion Street is now open. The applicant is requesting a waiver from the primary residency requirement for a short-term rental for a property located in the R1C zone district per section 5-31-4 of the Inglewood Municipal Code. Staff, could you please give an overview and please get sworn in first?
Do you swear or affirm under the penalty of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Eric Sampson, Planner 2 with Community Development. Good evening. This is a waiver request for a short-term rental for the property at 3336 South Marion Street. We'll go right into the approval criteria here. So when City Council passed the short-term rental regulations, they had waived the primary residency requirement for properties that were in the M1 or M2 zone district due to the proximity of these properties to the hospital and due to the lack of quality lodging options near these hospitals. So for the first criteria, the applicant does live close by, I think about 6 blocks away from Craig and Swedish. And then they did provide evidence to staff that they were working closely with Craig Hospital and that Craig would list their property as potential accommodations for visitors or patients to the hospitals. The second criteria is that the short-term rental waiver will not weaken the general purposes of Title V. So the Board of Adjustment has granted several STR primary residency waivers in the past. These have been done on a one-year basis, and with the intent that the operator of the STR return a year later to show that they have been indeed working with patients of Swedish and Craig, and that their property is being used mainly for those medical uses. So with those previous approvals have not impacted Title V, and staff does not believe that this will do so either. Finally, the third criteria is that the property owner will provide alternative means of assuring the goals of the regulations sought to be waived will be upheld. And again, for the previous waiver requests, there is a stipulation put in place by the board that they keep track of all of their stays and the reason for these stays. Again, the applicant will come back in a year and provide evidence that they are working with the hospitals, and that way we assure that the intent of Title V is being upheld. So saying that, staff recommends approval of this short-term rental waiver, again, on a one-year basis.
Are there any questions for staff from the board?
Yes.
Go ahead, Ms. Dickerson.
Are you going to inspect the property before?
Yeah, there is a requirement in the STR application process where the building division does go out and inspect the property to make sure that there are no life safety issues and that they have the proper amount of smoke detectors, carbon monoxide detectors, and fire extinguishers.
Are they going to need handicapped access? Because that was an issue at one of the waivers we did grant.
I don't believe that ADA access is required.
Okay. Now, the only other thing I can think of is, what does predominant mean in our context? Is it barely a majority, like 51%, or is it 60? Had we established anything like that?
We have not. There has been one waiver request that has come back, and then they were granted the waiver, I think, for a 2-year basis. And then they were able to provide that. I think it was a vast, like upwards of 90% of their patients were patients or visitors to Swedish or Craig medical facilities. And then that property is no longer operating as a short-term rental. So we don't, unfortunately, we're going to have another matrix that's coming up in the fall to measure.
What's the nature of the evidence that you require for them to come back within a year?
So that was basically a list of everyone who has stayed at the property and used the property as an Airbnb or STR, and the reason for their visit in terms of, staying at Swedish Medical or Craig, and that was the main idea from the board.
Can you share a little bit more about the verification process of that list? So just would that be basically, being handed a piece of paper with names and, reason for next to it, or is there a verification for making sure that that's accurate information? Does that make sense, what I'm asking?
Yeah, and I don't recall. I believe that the previous applicant just provided the list of people who had stayed there and the reasons that they had stayed there.
And is there any verification, say, like through the Airbnb platform? Is it just straight up from the property owner hands over a list, or is there any verification that goes into the information on that list?
Yeah, Airbnb does not keep track of the reasons for that they're staying. But yeah, that's all I have on it.
Okay, fair enough. I appreciate it. Thank you.
Is there any kind of guidance that you give to the folks that are keeping track about how to do that math about predominant? I know last time we saw something like this, they were taking out the longer term stays from that calculation, so those weren't factoring into their 50% plus one calculations. Is there any type of guidance that you're giving kind of as they're keeping track of like what information we might need to see in a year? I would have to go take a look back at the application that was
submitted for the previous extension for the STR to see what kind of information that they provided. But again, to the best of my knowledge, I believe it was just kind of a record of who had stayed and their reason for staying. I don't know if there was what kind of verification of the reason that they were staying was performed.
Do we have any other questions for staff at this time? All right, thank you.
Yeah.
I neglected to pass around verification and verification of the publication and posting of the property, so I'll pass that around so we can see that they did that step. All right, so now the applicant may come forward to testify in this case. All right, please state your name and address to the secretary who will administer the oath.
My name is Kristen Pyle, and my physical address, my home is 7552 South Emerson Circle, Centennial, Colorado, 80122.
Can you please raise your right hand? Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes, I do.
All right, thank you. Well, we have received the information in your application that was in the packet, but we'd welcome to hear other information that you may wish to present tonight on your case.
Absolutely. I think there's a little bit about it that really pulls at our heartstrings. So this property we've owned for numerous years, and it has been a long-term rental to the same tenants for 13 years. So we're very aware of its current condition, and we're doing a significant amount of work as we speak. Unfortunately, there were some circumstances that I just want to be forthright about. Our tenant broke her back in April and did not notify us. So she has been under the care of someone else for a period of time and had the other tenant broke his leg and since went back home. We were unaware that the property was vacant for a period of months, only when we found out that they were not going to renew their lease. So we asked them what was happening and if we could get access to the property. And so we are very aware of its current condition. At the same time, we have a solid relationship with Craig Hospital, which is just down the street. And we understand that there is a dire need for additional housing because when people go to Craig Hospital, they don't know if they're there for a week or a month or 3 years. The average patient stay at Craig Hospital is 2 years, and that is rehabilitation from traumatic brain injury and spinal cord injuries. So as we were thinking about, now we have this opportunity that this property is no longer rented to this long-term tenant, how can we add more value to this neighborhood and this community with our correlation with Craig Hospital? That's the genesis. So the idea isn't necessarily patients, which I appreciated the question about handicap access, because that is a big issue, but it's rather the families that are supporting those patients who don't have an idea of when they may be fully rehabilitated or what their outcomes may be. You know, there's a process for transitioning out of Craig Hospital once you've had your injury one way or another. So that's the premise of why we're putting in this application, is we feel like there's a great opportunity to help families who don't have a lot of choices on the table and don't have a lot of opportunities to stay anywhere else. Any questions? Sorry.
Are there any questions from the board?
Yeah.
Go ahead.
I've always been curious as to why you wouldn't make arrangements with Craig or Swedish or any group of hospitals to rent the property full-time, hands-off, and you wouldn't have to go through this process. Have you even discussed that with them?
We've discussed advertising our property with them so we can provide opportunities to their folks. But the problem with a long-term rental specifically is, one, Craig doesn't fund that for families. They provide the care for the family member who's injured. So they may have some offerings of housing, but they don't fund it, and it's not funded through insurance. In fact, sometimes the care for the patient isn't funded fully through insurance. So that partnership with the hospital is not an opportunity for us to bring to fruition.
I understand it isn't for patients, but we were told a long time ago that the hospitals were having problems with their nursing staff and finding places for them because they come for 6 months or 3 months or whatever. And that would be a different story altogether. And why they don't just rent some properties for these nurses to move into, I don't understand. But we're dealing with your issue now, and you just want to provide for patient care, right? And families at patient care.
I think that's an amazing idea, though. If they had nurses that would also need spaces to live, that would also be an opportunity for us. For example, I know that Children's Hospital staffed up on their traveling nurses. There was a point in history where they staffed up and they had folks who were only there for 7 days. So I think that could be an option for us. If I just don't think we've considered it just yet.
You had mentioned that you're currently making improvements to the property after a 14-year tenancy?
13.
13? Would you just mind describing some of the improvements that you're making?
So the tenants are required to put the property back in the condition it was rented to them in, minus reasonable wear and tear. And we've made several improvements over the course of the tenancy, obviously, including roof, brand new fence, HVAC, et cetera, et cetera. The thought process that we're going through now is the bigger improvements that we like to make, which we're taking a look. We just got 2 quotes on windows, brand new windows for the full property. We got several quotes on exterior. The bushes need to be cut back. We're debating doing that ourselves or not, because the arborist quotes were quite absurd. But that being said, we're trying to holistically, if we look at any type of comparable properties outside of the space of Inglewood, we have to hold a fairly high standard if we're going to do short-term rentals and be attractive. So we want that, right? If you're dealing with a family member in the hospital, the last thing you want to worry about is where you're staying, right? And it's condition, or like, we don't want to offer some janky property, right? So, sorry. Does that make sense? That would be the hope, is to get it up to a level that it would photograph well, show well, and be very comfortable to be in if you were going to be going back and forth to the hospital trying to figure out the next steps for your family.
Understood. So you said that you've received quotes on this work?
Yes, the tenants aren't vacated yet.
Okay. What is the timeline on that?
Friday.
Okay.
So we've done the full walkthrough. We've done, I think I have half a dozen quotes so far minimum, and then I have 4 other. I can't, you want to let them physically move out of the property before you can fully assess everything that you need to do. And so we're kind of waiting on that timeline to do the full walk.
So knowing that you are clearly accustomed to using this as a long-term rental, aside from a certain amount of care for neighborhood in terms of this need, is there anything else that's encouraging you to change the nature of your tenancy?
It's our first option to do it. We've been really grateful for long-term tenants. One gal went to DU Law School and she's a practicing lawyer in Colorado now, and the other got his master's. And so it's time to think about ways that we can change. So it's the first time we've had the opportunity.
Fair enough.
What was your timeline for completing the repairs
We just don't know yet. Because
perhaps you should wait to ask for a waiver until you know and it's available for rentals, because if it takes you 6 months,
it won't take.
You wouldn't be able to. And trust me, a neighbor of mine had her house burned and she's still not back into it. And it wasn't that burnt.
Fair. But we also understand that this process takes quite a bit of time as well, and there's an appeals process thereafter.
I'm sorry, I can't hear you.
We also understand that the public process takes a bit of time, and then there's an appeals window thereafter. So we are trying to overlap them for the best case scenario, in the hopes that everything works out. But I do not take your statement lightly. I understand.
Yeah, go ahead.
All right, so something that city staff said is the owner can demonstrate that the property is being used predominantly by guests who are utilizing Craig and Swedish hospitals. I know you mentioned you plan on advertising. If granted the waiver, how would you demonstrate that the property is being used predominantly by those types of tenants, guests?
As long as we have clarity on what's necessary, we will meet those requirements. So whatever y'all
Seems like
need.
it's not a lot necessary.
We received an email that was in our packet ahead of time with some complaints about the condition of the property, about no one shoveling, trash being left on the curb, overflowing. It sounds like you've partially spoken to some of this, cars being parked with expired tags, weeds overgrown. Do you have a plan for how to care for the property and keep that condition from happening moving forward?
So most of that care was under the tenants. And every time that we were aware of any problem, we promptly addressed it with the tenants. However, there's only so much power. I can't tell them that they can't store a car. That's their car, whether they drive it or not. Now, if it's on the street, then I have some power. So there's a little bit of the fine balance of holding your tenants accountable for the appropriate and proper care that they're supposed to be conducting on a property. However, moving forward, I think the intention is, one, to have a management strategy. So I don't think we'll be managing at arm's length. It requires a lot more of a lift and an effort to manage a short-term rental, including turnaround time. Obviously there's appropriate requirements in terms of when you can vacate and when you can occupy, and then all of the diligence that goes through that as well. And so the other part of that is again, we're not going to have someone come up to a tree that's a hazard, right? We're going to have to make sure that everything is exactly where it needs to be, to make sure that not only the folks who stay there are protected, but that we're protected as well, because it's our liability. So I think going forward, it's a management strategy and a more proactive approach in order to keep the property ready for the next family or person or need that arises, and being very proactive about it, rather than obviously someone who's a short-term renter is not going to be doing the lawn, right, or the maintenance or upkeep. So that's our thought.
So you think you'll be able to take better care of it as a short-term rental than as a long-term rental, trying to operate through tenant?
Absolutely.
Okay, thank you. Are there any other questions from the board? All right, thank you.
Thank you.
Are there any persons present who wish to speak in favor of this request? Okay.
Not in favor.
Not in favor.
Okay. Are there any persons present who wish to speak in opposition of this request? All right. All right, I have a sign-in list of folks who have signed up to speak in opposition. I will call in the order they're written down here. You will have 3 minutes to give your testimony to the board after you're sworn in. The first one up is Robert Heller. Could you
Raise your right
please
hand.
state your name and address to the secretary who will administer the oath?
Yeah, Robert Heller, 3750 South Cherokee, Inglewood, 80110.
Do you swear or affirm under the penalties of perjury that you would tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes.
All right, thank you. You have 3 minutes to explain why you're in opposition to this request.
Who's Trevor Pyle? Okay. Wow. All right. Well, I grew up in that neighborhood. My dad still lives there. For the last 13 years, that home has been an absolute dump. I've had to call in numerous times because they've had 9-foot thistles in the backyard. Front yard's always overgrown. The trees, branches have been broken down. Garbage has been stored in the driveway for months on end. And
if they're the owner, I don't understand why they can't come and clean the place up, but they've never cleaned it up. The house was an immaculate masterpiece before it was sold to them. And since then, it's just deteriorated, and it's the biggest eyesore in the neighborhood. I have had to call numerous times to have code enforcement come over and clean it up. I don't think that we need yet another rental property. And if it's any indication of how they've been taking care of this property, it's just going to be taken care of the same way in the future, with absolutely no care or thought about what they're doing. I can only see that they're going to be just having it as an Airbnb for people who are too drunk to drive home from the bars that are nearby, or just using it as a place to have parties in. And we don't need a party house in that. As far as them saying it's going to be for Craig Hospital, I don't even know how that works, and I can't even believe that's true. But it's the best thing for that property would be for them to sell it, and sell it to somebody that actually would care and keep that property up. But for the last 13 years, it's been the biggest dump in the whole neighborhood. That's all I have to say.
All right. Thank you.
Mhm.
Next up, we have Rebecca Kramer. All right. Please state your name and address to the secretary, who will administer the oath.
Did you want addresses? You said that you didn't to begin with. I'm in D2. I live on Lafayette around.
Hold on, Rebecca. Can I swear you
Oh,
in?
I'm sorry.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes, I do.
All right. So you have 3 minutes to share your testimony tonight.
Great. Thank you. Good evening. I'm here requesting that you deny the waiver request for this short-term rental for the property. The property is located in an R1C zone, district per section 531-4 of the Inglewood Municipal Code. The property owner has failed to maintain the property as a long-term rental. No one shovels when it snows, trash is left on the curb, often overflowing, cars are parked with expired tags, no permits, which are required for parking on that street. No permits are in the windows of the vehicles, weeds are overgrown. Oh, I do have 2 photos, if you could pull up the photos. Yeah, sorry. The yard is piled with trash, lawn's dead, weeds growing, huge thistles. It's only going to get worse, I think, if it's a short-term rental. I would also like to note that information contradicts the representations made by the owner that he has maintained the property. I have photographs which show the abysmal conditions. He also states that Craig Hospital has agreed to list this property on their official resources page. This is categorically untrue. I contacted Rachel Sherman from Craig Hospital, and she stated that not only are they not listed on Craig's local housing list, but Craig is currently working with the City of Inglewood to ensure that Craig Hospital is not included in these waivers. They have no direct involvement with these properties. Craig Hospital has its own housing, and it relies on its own resources, according to Rachel Sherman from Craig. That's the same individual that is named in the application for this. I have that email if you would like that, so you could read it from her. Finally, the house is located approximately a half a block from Charles Hay Elementary. We are an R1C zoned neighborhood. Short-term rentals are quite often, they end up as party houses and pot vacation destinations. This should not be allowed within the proximity of a grade school. Code Next was updated in the last couple of years when we updated laws, rules, and codes, and for a reason. If we ignore our responsibility to the citizens of Inglewood by failing to do proper due diligence, which that appears in this case, for variance requests and just rubber stamp them, then what was the purpose of having spent hundreds of thousands of dollars updating city codes? I'm asking again for you to deny the waiver and help preserve the residential neighborhoods of Inglewood. And as I said, if you want a copy of the email correspondence between myself and Craig Hospital, I'm happy to provide it.
I would appreciate seeing that. Yes, thank you.
Yes, and we did receive copies of your photos. We all did.
I don't know if they wanted to put them up or You're welcome.
And we can make sure that that email gets, can we have this copy to make sure it gets entered in the record for tonight?
You may have it, yes.
Okay, thank you.
I'm a fast reader, I promise.
All right.
Can you put that up on the screen? Or is that not possible? Okay.
I think we can. Do we just need one copy for this to be admitted tonight? If we all look at it tonight?
Vicky? We should make sure that we have a copy that, for the city to maintain as well. As long as we can also make clear on the record that all members have in fact reviewed it, so that there's not a question going forward.
Okay. We can make sure we're reviewing it. Thank you. You can go. We'll call up the next person after we've all had a chance to review.
Okay. Do you need me to recall me?
Thank you. All right, the next individual we have tonight is Brett Potomac. You'll have 3 minutes after you were sworn in. Please state your name and address.
My name is Brett Potomac, 3330 South Marion Street.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes. Hi, everyone. So we're not necessarily for or against this. We just have a series of couple questions and concerns we'd like to get addressed before deciding one way or another. The first one would be occupancy cap. Would there be a limit to how many guests are allowed? And if so, would this be tied to bedrooms, parking, or just a strict person number? Backyard use, would there be any outdoor noise limits? Events, would parties, weddings, reunions all be allowed, or would this be not allowed on wherever they rent this property? Quiet hours, would there be any, and how would they be enforced if there were some? Similarly, noise monitoring, would there be any on-site checks or any way to ensure the tenants or renters aren't being too loud? Parking plan, how many cars would be allowed? Would they be required to park on the property? We're actually the direct next door neighbors, just above on that picture right there, where the house just directly above it. And our driveway is built into the sidewalk and is easy to get parked in front of. And we've had people park in front of our driveway before. So that's another concern we have.
trash and cleanliness management. How would the properties get cleaned? Would there be like a maid or something that would come in after every guest? Last one, violations. If we are voicing concerns, us or others in the neighborhood are voicing concerns about noise, parking, or any of the other questions I listed, what would be the next steps? Would the permit be revoked if it was approved right now? And I think that's just about it. Last question is, would it be hosted on Airbnb, or what kind of tenants would be attracted? I think you mentioned it would be for the hospital, people at the hospital. I don't think that would be as big an issue as Airbnb might be. Like the other people mentioned, we'd be concerned if it was a party house. And with that being said, that is my list of questions and concerns.
All right. Thank you. The next individual we have tonight is Jesse Munson.
Hello.
Please state your name and address, and the secretary will administer the oath.
Jesse Munson, 3364 South Marion Street.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes.
All right. You will have 3 minutes.
Yeah, so my fiance and I moved to the neighborhood just over a year ago. We moved from downtown, right by Union Station, and mainly moved down here to get away from the noise. And so far we've loved how quiet and how friendly everybody is around us, and just really been enjoying getting away from the busyness of downtown. I guess my concern with the short-term rental is that I don't necessarily know how you would police it. I've been a teenager in this state. I've rented Airbnbs. I know what happens at those places when you just let kids rent it, or younger adults, and so it would just start to really concern us as to opening up kind of a revolving door of people coming into the neighborhood. We've had a chance to meet a lot of the families and people in the area. A lot of them have kids, and I don't think could kind of put a lot of people on edge if there's just kind of strangers coming in and out. And I think, generally speaking, it's a neighborhood we've grown to love, and we just want to, get to know the people around us and get to trust them. And with short-term renters, you just don't have the chance to do that. And I think it would just kind of affect the vibe of the street, if you will. So that's it. Thank you.
Thank you. The last person I have tonight is Peter Johnson. Please state your name and address to the secretary who will administer the oath.
Peter Johnson, address is 3363 South Marion Street.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
All right, so you'll have 3 minutes.
Just to kind of piggyback off what Jesse said, the neighborhood has come a long way. I've been there now 12 years, live right across the street and a few doors down. And, I think if anyone were to, give an opinion of how they wanted their neighborhood run, they'd rather it be homeowners than long-term renters or, short-term renters. And I feel the same way. Not to say that long-term renters can't be great neighbors, but they usually don't keep up with the house and do a great job of upkeep and just taking care and meeting the people in the neighborhood. It's my experience. There are quite a few long-term renters in the neighborhood as well. So, a short-term rental, you got to assume that's going to be even less care. And then as far as just the hospital aspect, it does seem to be a good idea, but I'm just very dubious that you can, handle that or make sure that it's just going to be renters from the hospital, especially if you're putting it on Airbnb. I mean, just about everybody's used Airbnb and VRBO and those, and it's the questions are minimal on there as far as just getting into a house. So it's my primary concern. Thank you.
Thank you. All right. Does staff have any additional comments at this time, or does the board have any additional
Andy, I
questions?
have one thing. I forgot to hand out this pamphlet from the email from Mr. Heller that we got earlier.
Okay. Yeah, we can look at that first.
It was in the emails. There's only a page here. I don't know if you want to read Mr. Heller's life.
Yeah, I believe these were in the added to the packet that we have tonight. But these are some extra copies of for the board tonight, just to make sure we've all had a chance to see it ahead of time.
I do have a few additional questions for staff, if possible.
Or is there any,
They're all the same. They're just multiple copies.
Oh.
Yeah. Okay. So the board's all had a chance to see these emails ahead and reviewed those as part of the packet beforehand, as these copies in case. All right. Sounds like we do have some questions from the board for staff now that we've heard some additional testimony. Just a reminder, you're still under oath.
Okay, my question is, on all the waivers we've done before when they involve these hospital things, we've gotten letters from the hospital and patients' families supporting a house. We don't have that here. Why would you recommend? And we also don't have any assurance that it's going to be available for rental anytime in the near future.
There was an email included in your packet that the applicant provided that was from Craig stating that
I didn't see anything from Craig.
Yeah, it was in there.
Did you?
Yeah, it was the one sent on. It was the one sent on this June 16th, and then the letter provided by the lady in the office. That email was marked, I believe, August 13th. So we do have two emails from Craig Hospital. One with information from mid-June, one with information from mid-August.
I
They
missed
are
that
contradictory
altogether.
info. Yes.
It was,
Oh, they're contradictory?
Yes, ma'am.
Oh, that's the difference then.
so it's page 10 in the packet.
Well, if they're contradictory, what's the deal on that?
That I don't know. I've only seen the one email from that the applicant provided.
Could you?
Oh, yeah, just the one I read as contradictory was the one that was passed through here that we were not able to put up on the board and
We can-
received this evening,
yeah.
but
If you don't have a question, we can do discussion in a moment, but we can limit to questions for now.
Okay, well then my question is, why would we issue a waiver if we don't know when you're going to be able to inspect and issue a license? Because it sounds like there's an awful lot of work to be done before they can even rent it out.
That's a decision that the board needs to make.
I'm sorry?
That's a decision that the board needs to make.
That's up to us?
Mhm.
Okay.
I was hoping that you could clarify what the owner is currently entitled to do by right without the variance, including what a short-term rental is actually defined as and what a other rental rights they hold without us intervening.
Yeah. So short-term rental is defined as any stay that is less than 30 days. So the applicant could do a long-term rental there with no licensing or no city requirements whatsoever. It's only for stays that are less than 30 days where the short-term rental restrictions and regulations apply.
And for further clarification, they're still subject to the same noise ordinances, code enforcement that the rest of the city is, and the neighborhood character is not negatively impacted by having long-term rentals.
That's correct.
Thank you.
What additional scrutiny or inspections do the short-term rentals go under? I think you mentioned some of the ones before occupancy, but is there anything over time with short-term rentals as part of that process?
We require that they renew their short-term rental license annually, and a part of that renewal process is an annual property inspection that's done by the building division.
Okay, so it's done annually.
Is any portion of that building inspection relevant to condition of landscape, since that seems to be a subject of complaint?
It's more basically life safety issues.
Tree of ill health hanging over house might fall under, or is that not even assessed?
I don't believe so. That would be a question for building division.
Fair enough.
So the zoning does not come into play as opposed to building department? Does zoning do a review?
The building division review is a part of the overall STR application review.
So in theory, the zoning would be, the condition of the site not meeting zoning standards would be noted at that time.
I believe, sorry, could you say that last part one more time?
Zoning requires we maintain the properties. So in theory, when you're doing the inspection, that's part of the review.
Yeah, I would assume if there were any sort of egregious zoning violations that would be brought to our attention.
I guess my point is that it's not just building department, it's zoning as well.
Yes.
Just as a follow-up on that point, is there anything explicitly outlined in zoning that would speak to the condition of, street-facing exterior? Like, I guess to be even more targeted, one of the complaints specifically cited, perhaps hyperbolically, 9-foot-tall thistle. Is that even against code?
That would be a code enforcement question.
Okay.
It may be more in the property maintenance
Brian, let
section
me
of the
swear you
code.
in real quick.
Oh,
Sorry. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Brian Isom, planning manager. So the maintenance of the property and landscaping, things like that, are not covered under the zoning code, but are likely all sections of the property maintenance code. So if there are issues with that, they would follow the typical nuisance process. So someone files a complaint, the complaint gets forwarded to the code enforcement department, code enforcement goes out and inspects, and then issues a notice of violation if there is one. The only time we really inspect landscaping is when there's a new construction project that goes on. We verify that the landscaping required was installed and sign off at that time.
Can we make a condition that any weeds have to be chopped down even if in their backyard? Because code enforcement will not inspect backyards that are fenced in by a 6-foot fence.
I would defer to city attorney on that.
They may not. Unfortunately, we're not experts in what code enforcement does, other than when we know we need to send somebody to talk to code enforcement. So that's when we would direct them to that. And if code enforcement
Apparently, I am an
backyard,
expert because I've had this issue a lot with code enforcement. But can we make a condition that that's part of the inspection process before you issue a license?
As part of a stipulation of approval of the variance request?
Mm-hmm.
I would defer to city attorney on that.
Sorry, I'm pulling up the the section. Well, first, with respect to the weed issue, those kinds of issues are covered under Title 15 of our municipal code. We do currently require for that premises inspection that the STR applicant comply with all applicable regulations. So any health, sanitation, and environmental protection requirements currently imposed under our Title 15 should be being addressed and picked up as part of that premises inspection. As for the conditions that can be imposed under Englewood Municipal Code Section 5-31-4 regarding the waiver of the primary resident requirement, the board can consider under subsection A, 2, alternative effective means of assuring owner oversight and regulatory compliance, and that the STR will not alter the essential character of the area, such as through implementation of a noise monitoring device or an affidavit from a medical facility establishing that the STR will be predominantly rented in support for patient care. So I would interpret the alternative effective means of ensuring oversight and regulatory compliance to permit the board the ability to impose certain conditions, such as what you're suggesting.
That's very helpful. Thank you.
And then can I actually ask a follow-up on that with the if we can ask for certain pieces of information to be collected with that with that process of creating the list of who is staying there? And I mean, is there a way that we can establish a requirement that we need a date rented, how long they were there, what the name was, what the reason was, what their email address is, so that we could verify this? Is there a way that we can kind of establish some stronger standards around what this list is?
So for that, there are two issues potentially. The guests are not doing business with the city per se, they're doing business with the owner, the license holder of the short-term rental. So with that, I mean, we could be imposing certain requirements that we would be receiving from the license holder. The second issue, though, we want to be careful specifically about what kind of information we're requesting when it comes to medical issues that people might be experiencing. There's it's HIPAA, the Health Insurance Portability and Accountability Act. We're not quite a covered entity under HIPAA, but if we are receiving that kind of medical information, we do have some concerns about that, certainly from a privacy standpoint. I know any record that is held by the city with certain exceptions can be subject to QORA. So we want to be careful about what kind of medical information we're receiving from individuals. So as long as we aren't receiving specific medical condition information, that is something that we legally could be requesting.
So, Victoria, thank you for that. I appreciate that. So to clarify, would we be able to maybe say, not necessarily asking the details of the medical visit, simply say collecting an email from that short-term tenant or collecting an email address from them where we can verify, yes, I was staying in this property during these dates and I was doing that because I had business at a local hospital that is listed on this information?
Yes, I think the city would be in a good legal position for that. We can also perhaps request something from a physician's note or doctor's note, as long as we didn't have any additional information about the underlying medical condition. Something that just confirms that the stay was for a medical purpose, but again, omits any like diagnostic or diagnosis, anything along those lines.
Perfect, thank you. And that's something that as this board this evening that we could attach as conditions of approval for the waiver, or is that something that would have to go back to council or someone else? Thank you for walking me through it.
Yeah, so again, because of that alternative effective means of assuring over oversight and regulatory compliance, that is a condition that this board could impose, and it's consistent with the current requirements for showing and establishing that the rental will predominantly be used for patient care or that connection to the medical facility. So yes, that's something that the board could do.
Thank you.
The board have any additional questions for staff at this time? All right, thank you. The public hearing is now closed. I need a motion and a second before we can start our discussion.
Chair, just before you close it and get that vote, can the board just confirm that that additional piece of evidence, the email that was received, everyone has received and reviewed it, just to ensure that there will be no further need for questions? Because once the hearing is closed, we can't receive any more evidence and ask any more questions. Just from a procedural standpoint, if that can happen, thank you.
Yes. All right. The hearing is not closed. Just to confirm, everyone has had a chance to see this email and then the additional email that got passed around. We did all take time after the testimony. Can everyone confirm that they've
I have a
read
question
this?
for
I
Vicky.
saw
I'm
it.
sorry. There is an extra name on their email that wasn't announced. Do we need to, I got two emails. Mr. Keller was here, but Ms. Keller wasn't here, but she has an email that she sent that I printed off. Do we need to state her name and proposition or?
She provided, I guess, written, through her email, she's providing a written stance on her view of the issue. I guess, but we have her name and her statement. I mean, she's not here to testify, so we wouldn't have been swearing her in. Procedurally, I don't think anything additional is necessary. Well, actually, let me clarify. You're just saying, like, in terms of assessing how many, for or against, is that, I would include her in whatever, I guess if she's against, I would include her in whatever tabulation you're keeping on the for and against.
I also, just as a point of order, I did want to ask the board if there were any additional questions of the applicant at this time. So everyone has had a chance to see the emails that were included in the packet electronically tonight, but that were also available via print from Robert Heller, the Hellerado at hotmail.com, and Jennifer Heller. Those two email. Everyone had a chance to review those. I'm seeing head nods. And then the additional email that I watched us all have a chance to read tonight from Rachel Sherman at Craig Hospital. That was dated August 13th.
The other one was like June 12th.
Yes, and the one in our packet was June. All right, so not hearing anything else, I'm now going to close the hearing. The hearing is now closed. I need a motion and a second before we can start our discussion.
I move we start our discussion.
Well, we need a motion on the
Closing.
To grant the waiver.
I move we grant the short-term variance waiver at 3336 South Marion Street. The applicant is requesting a waiver from the primary residency requirement for a short-term rental for a property located in the R1C zone district per section 5-31-4 of the Inglewood Municipal Code.
All right. Do we have a second?
Second.
All right.
That one's easier.
Discussion.
I am reticent for us to add additional criteria to an approval that we haven't done in the past simply because of the nature of some of the pushback we're getting. They're still entitled to the same process that every other resident has received thus far before this board, especially understanding that many of the conditions that were stated are still subject to the same level of oversight as any other resident in the city of Inglewood, including additional encumbrances by the building department for an annual review and code enforcement. I also think it's worth noting that a few of these pictures look like they're through the fence lines into the backyard. Not to say that it's a particularly attractive condition, but it's no different than any other resident may decide to keep a certain level of maintenance in their property. It's a higher standard for arbitrary reason.
And I agree with that. I'd also say that if we add extra stipulations, we're asking staff to do extra things that may or may not happen. I'm not sure that's really a realistic concern either.
Well, and to clarify, the reasoning for my questioning was not necessarily the advocating for placing those additional standards. It was simply to try and understand what those standards are and then what the options might be for the applicant and for this board around that. I was asking those questions in part because it seems to me that if you are someone that, and not necessarily saying that this is true of the applicant, I do believe that the applicant really wants to help folks that are working or seeing folks at the hospital. But if you're the type of person looking for a loophole, if you can just write a list of names and say they were at the hospital for this, it seems like a very, very low bar of actually proof and verification. I do not advocate us placing additional requirements on the staff. We don't have the money for that, the budget, they don't have the time, but I am very surprised at how low of a bar it is to really get this waiver.
It would still be perjury, though.
Fair.
You would have to submit this before the board. No, sorry. Still be perjury.
Sure, yeah, and again, I don't believe that these applicants want to perjure themselves or perjure anyone, but I'm just surprised in terms of how the process works and how this is currently set up, that is the option, because many people are not afraid of perjuring themselves because who is actually checking up on it? And with the process that we currently have for accessing these waivers, there is really no checking up on it. You could kind of say anything. I mean, I could hand someone a list that says, Christopher Columbus stayed at my house from, March 17th to June 20th. And okay, how do we verify that? I know he's been dead for many hundreds of years, but who's checking that? How do we know that?
Highly dubious long-term resident. I do think that kind of goes back to a conversation I believe we've had in a couple forums so far, where it would be nice to get a little bit more of a formal system of guidance from either staff or through code as to how we want to measure or handle these situations.
I think we've struggled with this in the past of how council has set this up for us and what we can, like the process we have, the criteria we have, and I think that's been a struggle. I think we have put conditions on this to make sure that these waiver requests are no longer than a year, and that gives us as a board another chance in a year to see this additional evidence, because it is hard to show that this is being used for medical purposes when it hasn't been a short-term rental yet. So it's hard to prove something that hasn't happened yet. And so that gives us a chance. That's a condition that we can put on to make sure we've changed that deadline to try to tweak it to make sure that we are considering the waiver before the renewal of the short-term rental license, which I believe is an annual requirement. And so there are some things that we have tried to do. I agree that looking at the evidence that we see, we do have to take a lot of word for it as the people are submitting material that is truthful. So it is very different from other things that we see and hear as a board, but it is a purpose that council has put in front of us to see that short-term rentals can happen under certain circumstances. So I I think we should try to stick to the criteria in this decision of, do we think these three criteria that the council has given us can be met or will be met? And then are there additional conditions that we would like to add to ensure that that's the case? That's the other thing that's in our purview.
I think just in discussion here, to me, all the criteria are met. Our problem is with poor maintenance for 13, 14 years. And I suspect that in order to do short-term rental, they have to maintain it in a much better condition in order to do that. So I think that part's hopeful. The concerns about some of the people have brought about noise and so forth really is but it's really no different than anybody else living there. Those mechanisms are in place. So that's kind of my opinion.
Yeah, in terms of the third criterion about assuring the goals of the regulation and that character the district is met, that actually they'll have more access to the property with it being a short-term rental, to try to address some of these issues that have cropped up previously as a long-term rental. Yeah, go ahead.
So in the municipal code that the attorney read, 5-31-4 waiver of primary residence requirement, there is a condition, so alternate effective means of assuring owner oversight and regulatory compliance, and the short-term rental will not alter the essential character of the area. It's a pretty broad term. I think I want to see how the rest of the board interprets, and the short-term rental will not alter the essential character of the area within this, because the evidence from 13 years is that I don't think that the property owners have taken care of the place. I'm not sure how to interpret this will not alter the essential character of the area. Any thoughts?
Yeah, go ahead.
I don't think there is any essential character of a neighborhood. Everybody is required to keep their property. Whether it gets enforced or not by anybody is another matter. And I think they are providing themselves with an opportunity to take control from a management standpoint of the property. We have to see if they actually do. And that would involve planners when it comes up for a renewal, or us. And people can complain, hey, they didn't do it, and they can bring in the pictures and all the other stuff. But it's not going to come into effect until they get the license from planning. And the planners are responsible for making sure that the property is healthy and safe. And frankly, if there are weeds of any height that are blooming, that is a health issue. So I think they can make that condition. Oh, nope, you've got grass and weeds and they're blooming, and it's regardless of whether it's below or above 6 inches, they can make that condition. But it's not going to go into effect until they get the license. The waiver isn't going to go into effect until they get the license. And so they got a year to prove themselves, and if they don't, they get yanked.
The character is pretty broad, and this is the kind of interpretation that we get to do as a board for the things that are in these criteria. So I think we did hear some testimony tonight from folks that were saying, you know, I want to get to know my neighbors and have neighbors, and I am, you know, I do hear that argument of, you know, as a short-term rental, that is a change in the character of the neighborhood, that you don't have consistent neighbors like that or things like that. So I think we can look at that pretty broadly if folks do want to see it that way.
I mean, this is just pretty broad overall. I mean, the lack of clarity, I mean, not necessarily lack of clarity, but the lack of information needed around, lists is one thing. And then the lack of what does the word predominantly mean? Is that 50 plus 1 of the tenants? Is that 50 plus 1% of the time of the rental? Is that 60%? Is it, I mean, it's all wildly broad. I just wanted to say, I agree with you and that we're not in a great position here because it is so broad in so many different areas.
Yeah, I had that question for staff about, because last time we saw some of this math in one of these lists was, oh, well, I don't have to count these because these were longer than 30 days. So my 50% calculation doesn't include, and it's not every night because it's not booked every night. So it's the math can be a little complicated.
Yeah,
But
of every tenant, of amount of time it is rented, of amount of time it's rented of the people there. I mean, that could mean
right.
so many different things.
Predominant, is does that mean every use when the property is not in use? Is it? Yeah, but I want to make sure we're hitting everyone.
I have just a thought about that. If they're advertising through Craig and whoever said they weren't just doesn't know what's happening. If they can document referrals from Craig, just say, this came from Craig.
They may not
Regardless of
have
what
a
the
way of
purpose
knowing
was.
that, though. They're listed on the website as a potential resource, and if I'm not mistaken, that website is just going to simply point them to the available listing, which is
So there's not going to be a
through-
direct referral.
Yeah,
Right.
and pertinent to that email that we just all read tonight, Craig may not want to volunteer to participate in this system of oversight and accounting. I don't think that that's necessarily going to be a system that's set up to succeed long term. I do think it's up to us to start to establish what those standards are, and if it is a list and of occupants that qualify under the short-term stay, I think I would advocate that time is the better metric there as opposed to number of residents.
Well, I wasn't objecting to that. I was just
Yeah.
saying that if there was a referral and the tenant said, I got your information from,
Yeah.
That could be something they could add to the list. They received this information from the advertisement on Craig.
So
And-
you're requesting that for potential tenants on Airbnb, they have a question essentially that's like, did you hear about us through the hospital system?
Yeah, and they'd have that recording.
But I think as we heard, the ultimate short-term tenants are not doing business with the city, so they don't have to answer that question.
Exactly. We kind of have an imperfect tool set, and I think that at least all we can do to move forward is to expect the best out of our fellow residents and assume honesty until it's proven otherwise. I mean, we don't really have a metric to doubt, honestly.
And we can give it a year, and with that condition, are there any conditions we want to consider to add to the motion? I'm not clear if the motion is for a year or if it's.
I think it was a year.
Right now, we have not added the motion that was suggested by the staff, and that I would like to make a motion that we add to our approval, whatever it is.
We amend the motion.
Yeah, that the request be approved for a 1-year duration with the requirement that guest records are kept and that the owner can demonstrate that the property is being used predominantly by guests who are utilizing Craig and Swedish hospitals. So when we come, that's the end of the motion adjustment.
Do we have a second?
Do we have to
Second.
limit it to, excuse me. He seconded it.
Second.
The
Did you-
discussion is,
Yeah. So, I mean, that means we have to monitor it in a year now. We want to
Yeah.
hear about it. And I agree with you. It's like, we've got to trust people. We got to trust the process a little bit.
well, shouldn't we just say hospitals in general?
Instead
Because
of
Craig
Craig
is
and Swedish.
right exactly by Swedish. And neither one of them are very far from Porter.
I'd be willing to strike the words Craig and Swedish from the
hospital patients and families
Hospitals.
and nurses or whatever.
We're usually utilizing the hospitals, period. Still need a second on that.
Second for the strike.
There's a friendly amendment, and it's the seconder concurs. All right, so the motion is to restrict the waiver to a year and to require documentation, so as you spoke, and then documentation of the stay involving local hospitals. Is that what we're saying?
Verbatim, it's that.
Got it. So I will read this just so we all know for discussion and vote on the motion to amend the current motion. So the request be approved for a 1-year duration with the requirement that the guest records are kept and the owner can demonstrate that the property is being used predominantly by guests who are utilizing local hospitals, or utilizing hospitals. Sorry, I added the word local.
How about not hospitals, medical? Medical treatments, including hospitals.
I think by nature of how the variant structure was written, that it was specific towards the medical district within the city. I guess just to give us some kind of guardrail so that someone can't have like a 14-day spa retreat and then list it as such.
Could we say recognized Inglewood Medical District? Is that specific enough, or?
I mean, it works
Fair
for me.
enough.
I don't know about the categorical from a legal perspective, but
Yeah, because I mean, I like that language. I just don't necessarily know exactly what qualifies as Inglewood Hospital District. I have a feeling I know what I feel like I would classify that as, but do we have a definition of that? You know, I like definitions, as you can tell.
There is a zoning district that is medical. There's a medical district.
But it
Medical
doesn't
zone
include
district.
Porter, because Porter isn't actually an Eagle.
Correct.
I mean, I'd be happy to take the word hospitals out and make it medical district.
For access to medical.
So the potential amendment to the motion would be that the property is being used predominantly by guests who are utilizing
Services of the medical district.
services in the medical district.
if I run a business though in the medical district and the guests utilize my services, that like this is just where it gets a little we're going down a rabbit hole.
I mean, I think as the condition that we're putting on potentially related to this first criterion about special circumstances or conditions are tied to the medical M1 and M2 zone districts because of Swedish and Craig.
Medical services. Not necessarily because there could be other things in the medical district, but medical services.
I may not understand, but who are we to judge what a medical service is? I actually think maybe sticking with the original language because that was the original grounds for the variance is probably wisest.
And that's technically what we've done on the previous one.
Yeah.
So we'll be back to leaving the two hospitals in the name then.
Okay.
So I will restate one more time that I'll make the motion then. Request be approved for a 1-year duration with the requirement that guest records be kept and that the owner can demonstrate the property is being used predominantly by guests who are utilizing Craig and Swedish hospitals.
Seconded.
So to clean this up, we should probably, because we had a motion to amend the motion, and then we had a friendly amendment to change that motion. We should probably vote on that.
We can't just simplify this.
Are we all okay with just doing the final motion?
Yeah. I mean, as long as
absolutely
staff are, I think we've the motion and the seconder have agreed on what the language is. So let's take a vote. All in favor of the amendment to the motion, please say aye.
Aye.
Aye. Any opposed? All right. Back to discussion on the original motion with this amendment. Is there any further discussion related to the criteria now that we have some conditions in place?
I think it's worth us defining what predominantly means and sticking to it moving forward.
I would very much agree with that, yes.
I would really like to find a way to communicate this to council about some of the confusion about this language and some of the restrictions and difficulty we're having with lining up timelines and, you know, with the reapprovals and these other things.
Yeah, like I'm sorry, go ahead.
Well, the odd thing about it is essentially we can define predominantly when they come back in a year if we want to. It's up to us at that point.
And if it's only 51%, we can
We're
say
gonna go
that's
in.
not quite good enough.
But the problem is 51% of what? 51% of every night of the year, 51% of the nights booked, 51% of the nights booked for a short-term rental. That is not clear, and we have to decide that in a year.
Can't we decide it now? It feels disingenuous to do it after the fact. Like, sorry, you didn't meet our goal that we didn't tell you about. Like,
No, at a year,
I mean,
the condition would be if they didn't meet anything, not even 51% of stays,
that's what I'm saying. We should define it now.
then the condition of the renewal for one more year would be 60% of a specific, like if it wasn't rented out, but for 6 months out of the year, total days.
Yeah, I understand. I'm saying that it's.
But not do it until we renew.
Mhm.
Then put a different standard on for the renewal if they don't even come close.
I mean, we're not writing this down in code, so like we either have to put it in the motion or leave it vague. And
I just see utility in at least having something amidst this board that is the standard moving forward, because we seem to have enough of these. And either way, this problem is just going to keep coming back to us.
it's really up to whoever is interpreting this language on the board in a year. So like, I'm not gonna.
That's fair.
If someone wants to show their math and show their work in a year, I'm willing to take that into account. And if that's not good enough for whatever the board is in a year,
Board can say no.
Fair enough.
I think we could arm wrestle on what those terms are for another half hour, an hour. So.
Feels a little unfair from the applicant side to not know exactly what your stipulations are going to be, but I don't disagree with you. I hear what you're saying. I do ultimately agree. The human side of me feels a little bit for the applicant side.
I'm with you.
It's really unfair to ask people to go by a process that we ourselves can't even define.
I think for the sake of discussion and what I've seen and what has been helpful information for me is just the nights that it is being rented out. Like I think nights is a good measure rather than stays because there are some of these that are going to be 2 weeks. There are some of these that are going to so if someone can show number of nights and number of stays and show that math and do both things, like show that it's predominant in terms of nights, I tend to think that is good. If it's empty, I don't really want to count those against someone because that's just the way short-term rentals work.
So to be clear, we are talking about a standard, though, right?
Yeah.
I'm opining on what future me will think verbally, but not factoring that into.
Okay.
I mean, if someone wants to amend the motion again, I just. Yeah.
I appreciate that we're trying to build in flexibility for a board composition that may be different in a year, but honestly, from like an empathetic perspective, that would be maddening if I was a family trying to achieve this loop or this next step in our strategy, and suddenly the rug gets pulled out in a year. And we may not have the ability to enforce that, but at least we can set like something that staff would then record that if all of us are hit by a bus in 6 months, they would read out in the case in 6 months after that.
We can either amend the motion, but we can't record anything that would be documented in code. Like that.
I know it's not part of code, but
Right.
would it be part of the review of the case in a year's time? Or would that I suppose that's a question for staff, which we may not be able to do at the point. But
Well, we're only doing it for a year, and anything can happen in a year. Council can change the whole thing in a year. And so they're good for a year. And we could have all these people complaining about them still in a year, and then take that into account.
understood.
There's a whole bunch of different factors. You know, it's fluent. So I think limiting it to a year, and they know that anything could change in a year. And we did have one where they were able to prove that they had 90% according to the planners, and they're no longer even doing it. These people might decide to sell in a year.
I think the other thing is that they're listening to us talking about this. I think they get the drift. So I'd call for the vote.
All right. Get back to my point in the script here. All right. Ms. Warwick, please take the vote.
Mr. Cole,
I vote in favor.
Ms. Ozzles,
Shockingly in favor.
Mr. Friesen,
I vote in favor. I think the first criterion is met. Proximity, both the Swedish and Craig, makes it appealing. Second criterion is also met. I think the applicant, even though they reside in Centennial, will be close and able to look at issues if needed. And I think the third criterion, though, it's a little bit vague what essential character means. I don't really think the use of the STR really does much in that respect.
Mr. Koenig,
I think the first two are pretty clearly met. The third one, the property will be used as a short-term rental, which is allowed use in all residential zone districts with appropriate licensing. The use of this property as a short-term rental will not alter the residential character of the neighborhood. I think the applicant made it clear that they think that they will improve the character of the neighborhood by being able to do more maintenance. I think a key condition for 3 is we'll come back within a year. We'll have a public hearing to see if neighbors agree with that, and that they meet the condition that Craig and Swedish hospitals are the primary guests. So I vote yes.
Ms. Dickerson,
You? Oh, me? Okay. For all the reasons stated and understanding that we have a limited thing we can do with this. And I would kind of ask council or staff to address this issue with council. I agree.
Chair Taylor,
I voted yes for the reasons stated.
motion passes 6-0.
All right. Thank you. Next on the agenda is, gotta get back up to the top. Next on the agenda is staff's choice. Do we have anything for staff's choice tonight?
No, I have nothing tonight.
All right. Attorney's choice, do we have anything?
I'll just say that, yes, we understand the issue with the code language. Our office will look at it and we'll see what we can do in terms of discussing it with council.
Thank you. Board member's choice, I think we've expressed a little bit
expressed a
tonight.
lot.
It sounds like we were heard about the process.
Do we need to do anything to formally ask that
Yeah.
they look into that?
I think.
Well, she's already said she will.
Yeah.
Okay, so that's good assurances. Okay.
Yeah.
If we all agree, I'm happy with that.
Excellent.
I just wish we'd been hearing this case in about 2 months from now, once things had been taken care of, so that the neighbors were not as stressed as they understandably are right now. But now I'll shut up.
Yeah. No, we appreciate everyone coming out tonight to talk. And Yes, we definitely appreciate hearing all these things. All right. Well, with that, we can stand adjourned. Thank you, everyone.